Thank you for listening and supporting the Daily Memphian. Sign up for one of our many free newsletters and breaking news alerts at dailymemphian.com/email to receive the latest local news stories impacting our community. Our weekly newsletters cover everything from sports to arts and culture, business, food, and more, along with daily updates of all the news we publish each day. Sign up or manage your email preferences at dailymemphian.com/email.
I'm Bill Dries with the Daily Memphian. We are talking with Janika White, a candidate for District Attorney General in the May Shelby County primary election, and this is on the record. We record this Monday, March 21st, 2022. This is one of three On the Record podcasts with the three candidates for District Attorney General and the Democratic primary featured in our comprehensive story about that primary race. The winner of the primary will meet Republican incumbent District Attorney Amy Wyrick in the August county general election. Wyrick is unopposed in the May Republican primary. Ms. White is a partner in the law practice of Bailey, & White. She has represented clients in high-profile criminal cases and civil litigation. She has also been involved in urban ministries at Bloomfield Baptist Church, where her uncle, the late Ralph White, was pastor for many years with initiatives that went toward many of the criminal justice reform issues now being discussed in this campaign. So let's start as a defense attorney and your experience there with cases in federal court and in state court. Are there differences that you have seen in how cases move through each of those systems?
Oh, yeah, absolutely. There's a huge difference in terms of cases being more streamlined, and the way that the process works is just more organized. But at the beginning of any criminal case in federal court, we do a scheduling order. The court is already looking to see when will this case be set for trial. Discovery is produced very early on, almost within days. Well, not almost, within days of arraignment, you get discovery, especially any Brady material. But the process is much more streamlined and organized in federal court, just much more professional. And those cases are tracked by the judge, whereas in state court, it's up to the prosecutor more to keep those cases moving.
Is some of that a function of there being more cases in the state system than there are in federal? Do you have less of a caseload in federal than in state?
Yeah, absolutely. Absolutely. Mm-hmm. In federal court, we have a much more structured scheduling order than we would in state court. In state court, you generally wouldn't have a scheduling order at all. You may get a trial date, and then, of course, you know that all of your activity works backwards from that point. But absolutely, to answer your question.
Mm-hmm. Let's talk about what is at stake here that all three of the contenders in this primary, yourself included, have talked about and agree on, and that is change in the district attorney's office. Why do you feel that there needs to be change in that office?
For a myriad of reasons. One, the results that we are seeing are failing results. We see that crime is increasing, the community is less safe, incarceration is going up. We are constantly making the news, national news, for negative reasons. In addition to increase in violent crime, we're making news for ethical violations that have occurred from the office being accused of withholding Brady material, which is evidence that should be produced. Mm-hmm. We've been in news for issues of over-prosecuting, such that people end up pleading to some crime or some lesser offense, even if the person has maintained innocence. We've had issues with the office refusing to create a conviction review unit to be able to correct any previous convictions that may now have new evidence or some type of misconduct that has occurred. We are transferring youth in disproportionate numbers from juvenile court to adult court. We're failing at crime prevention and rehabilitation of our youth. The list just goes on. We need change, and we need it quick.
And you have told your supporters at several campaign gatherings that I've been at that if you win the primary and then you win the general election, that there's probably not you're not going to walk into the office with a massive restructuring plan. That what's probably going to come first is that you're going to do a lot of listening on how you think the office needs to change from other people, right?
And I'll tell you, we've been doing a lot of that work now. I've been dealing with this campaign. Bill, this is my first campaign, but I've treated this campaign just like I do when I prepare for a trial. When I prepare for trial, I start a case as if I'm going to trial, and I work backwards. So what do I need to look like on trial day? And so I've started with this campaign, same thing. I'm running it as if I'm going to win. So what is it that I need to be preparing myself for on day one? So we are doing a lot of listening and having a lot of conversations, but I'm doing that now. I'm speaking with experts now. I'm speaking with people in the community on a constant basis. And people will tell you who followed my campaign, my platform is constantly changing. And not only the platform, the way that we may achieve some of these goals, that's constantly changing as I listen. So when we go in there, especially once we make it out of this primary, we will start developing plans and continue to meet with those people who we think have, information or input that can benefit us. But I'm developing that plan as we go.
Okay.
So on day one, we'll have a 30-day plan, a 60-day plan, a 90-day plan. We'll have these milestones to know this is what we need to change, and this is the time frame that we want to change it in, and this is how we'll affect that change.
So does this mean a lot of turnover in who holds positions in the office currently if you're elected?
I can't say that, I can't say that, and I won't say that because I don't know that to be the case yet. Of course, you'll have some people who may not want to stay once a new administration is in place, but we will have done our homework on what has previously occurred in the office in terms of any ethical violations and just overall case management. So, of course, with anything, we'll have to do an assessment. An assessment will be necessary, and I'm doing what I can do while I'm on the outside of that office. But once I actually take the office, we will need to do an internal assessment and audit to determine, to identify those areas that we need to start changing.
One of the things that I've come across in watching this campaign and watching the whole criminal justice reform issue unfold in our community is that I talk to a lot of people who are not attorneys, who do not have contact with the system on a daily basis. And they tell me that they think, okay, the district attorney is one side of two in a battle between what lawyers often call zealous advocates, one side making the best case for guilt, the other making the best case for acquittal. Is it as simple as that, do you think?
I don't. And the reason I say that is because I think we get so caught up in the advocacy part of it that we oftentimes forget that the prosecutor's office is an office that represents the people, the state of Tennessee, and in our district, that means Shelby County. And that means that office is also responsible and has a duty to be a gatekeeper. And what I envision as a gatekeeper is one that does not bring cases where there is not sufficient evidence. It's an office that does not overcharge where there's not enough evidence to sustain a higher level charge. So a lot of times we forget that the prosecutor's office actually is that first line of defense to sift through what information is there. And so before we get to the point of being a zealous advocate, we must have a prosecutor who acts as that gatekeeper and ensuring that we're not unjustly proceeding on cases where we shouldn't be.
Okay.
And so with that said, yes, the advocacy part is important. And of course, within the prosecutor's office, you want experienced trial lawyers, and you do want zealous advocates. But you want zealous advocates from the standpoint of working ethically and within the rules. One thing that I will say that I've learned and that I have really practiced through the years is, and I appreciate Mr. Bailey for this, because this is something that he has always expressed to me. You don't get to choose the hand that you're dealt. We have to play the hand that we're dealt, but you don't get to choose the hand. And what that means is you don't cut corners, you don't change things, you don't break the rules. You work with, if you're a zealous advocate and you're an experienced trial lawyer, you work with the hand that you're dealt, but you do it within the rules.
Mm-hmm. Let's talk for a point you raised about juveniles, children who are transferred for trial as adult. That's a recommendation that the district attorney's office makes and that the juvenile court judge rules on. If you're elected, what about the district attorney's relationship with juvenile court on that matter specifically would change? How would the process be different than what it is now?
One, right now we're using it. The statute says that you may transfer a youth from juvenile court to adult court. Right now we're using it as a shall for a very broad list of what have been named violent offenses, some of which arguably are not.
Okay.
I say that to say, one, changing that list of what's categorized as a violent offense, but two, working with our office to develop an actual system when choosing when a child or youth should be transferred from juvenile court to adult court. This is a matter of, you're saying that this youth cannot be rehabilitated. We're giving up. In my opinion, it's equivalent to the death penalty, because we know the negative consequences that follow a youth being transferred to adult court. That young person is 85% more likely to be sexually or physically assaulted, and that young person is more likely to be a repeat offender. Because when you're talking about making that transfer, that youth is looking at generally at least 7 years in adult court. And so that's a decision that should not be made by one prosecutor or one individual. That's a decision that should be made after a developed process of an assessment, not just of the youth, but of that youth's environment and family, a psychological evaluation, detailed background and history of that youth, as well as a decision that's made by multiple seasoned prosecutors as to whether or not a child will be transferred from juvenile court to adult court.
And the incumbent has also said that a prominent factor in making those decisions currently is protection of the public. Where do you think that falls in the process if you're the district attorney general?
Protection of the public is very important. That is the number one priority of the district attorney's office. And we have to make sure that the decisions that we're making are getting us to that outcome. And so to that question, I say history has shown us that those type of decisions does not get us to our ultimate outcome of safety. Because what history has shown us is that youth is going to eventually be coming out of prison in probably about 90% of the cases. They're not sentenced to life in prison. And so now you're talking about a youth that we've sent from 14, 15, 16 years old to adult court to continue their development as an adult in prison and then now be released back out to the general public. I submit that doesn't create a more safe environment. We must figure out how to create change within the trajectory of these youth's lives before we say, hey, we're throwing our hands up and transferring you to adult court, because we realize either we're going to face it now and deal with it, or we're going to pay for it later.
Mm-hmm. So much of the discussion locally about crime and punishment has gone something like this: lock up the repeat violent offenders and offer alternatives to prison for non-violent offenders. And if you hear it enough, it can sound to you like there are two types of people facing charges in the criminal justice system: those who only commit violent crimes and those who only commit non-violent crimes. Is that your experience as an attorney? I mean, is it you're either one or the other? And if you're one, you're locked up for a long time, and if you're the other, then you have a chance at rehabilitation?
To answer your question, no. And I'm so glad you pointed it out. It is not that simple. It is so complex. The way that I get to see your exact question has been in federal court. In federal court, once a client is sentenced, we get this long paged, it's called a pre-sentence report. And it lays out an individual's history from birth all the way up until the point of where they've committed this crime, pled guilty, and now are being sentenced or found guilty. And so many times I've had clients that do not have a violent history, and some who've been accused of or they've pled to, quote unquote, a violent crime, but it's not what most would consider a violent crime. But interestingly enough, when I get so many of my clients in federal court and I read these pre-sentence reports, many of my clients started to get in trouble around 14, 15 and had these contacts with the juvenile court system. What I've learned through the years is that the majority of my clients who had been in trouble for all of these years, so from age 14, and I'm now representing them at 37 or 42, or sometimes even 23 and 24, have never received any type of assistance or resource that could possibly deter the behavior that they have been repeatedly committing. So many times at sentencing in federal court, I'm trying to convince the judge of these, what we call mitigating factors, the sentencing factors. And I've had my clients do moral recognition therapy, financial literacy, parenting class, got my clients mental illness treatment, substance abuse treatment. And when I tell you, and the judges down there can tell you, those programs work. Unfortunately, people go through the system for years and years and years without any type of intervention because our response has been lock everybody up. I can't sit here and tell you that today I can list you out what crimes will more likely than not lead to more serious conduct, such as a violent crime. But I can tell you, no, you can't separate people in that way. That's just not realistic. But there are experts and there is data that can help us guide the type of policies that we make so that we can try to have more people who are productive citizens of our society, because that's not us being safe on crime. History shows us and tells us, and the data tells us, that once we deal with people as people and give people what they need, you can change behavior. But we have to be really intentional once we have these contacts with the criminal justice system, instead of saying you've violated our social contract. And the only way that we can hold you accountable is by incarcerating you. So we see that doesn't work.
Okay. So where in balancing a number of factors do you put the voices of the victims of crime in weighing what happens to the person who is accused?
I think that's an important voice. I don't think it should be the absolute leading voice because, again, the prosecutor's office represents the people. So you have to make sure that the decisions you're making generally reflect the values of the community. But of course, the victims' say is important. But right now, our victims don't get the treatment and the resources they need after being a victim of a crime. For so many crimes that we know, they're traumatizing, and that there's trauma that needs to be addressed. And that, again, another place where once we have that touch with people, we can be a connector to the things that those people need. Victims do need more assistance and they need more attention. I do believe the voice of the victim is a factor. But of course, we know that has to be just that, a factor that's to be considered and weighed with a myriad of other factors.
Mm-hmm. In weighing all of those factors, is the mechanism for this exclusively inside the district attorney's office, or is this something that really reaches beyond that?
You mean in terms of overall change?
Well, in terms of what you've talked about specifically for determining who gets charged, what the severity of the penalty should be, whether you come to some mediated solution on how the case will proceed. All of those things that you've outlined in our discussion as being needed, evaluation similar to the pre-sentencing report in federal court. Is that all a function of the DA's office, or is it a broader kind of infrastructure?
Oh, okay, I get what you're saying. So yes, those things that you just mentioned are all functions of the district attorney's office. They work in conjunction with, of course, pretrial. So when you get that pre-sentence report, that's something that generally comes from pretrial. You work with, of course, in the context of restorative justice, that would include working with community leaders as well as community members and the victim and the accused to come together to create solutions, to create whatever kind of disposition the accused will have. So each thing that I've mentioned it's led by the district attorney's office, but it has different components that require other agencies or groups or people to really make it work. But I absolutely believe that the DA's office is the leader of those efforts.
Mm-hmm. A final point, several national criminal justice reform groups have gotten involved in this challenge of the incumbent without backing at this point any of the three Democratic challengers, and with a lot of criticism of Amy Wyrick's record. How closely aligned are you with what those groups are doing politically in your pursuit of the office?
I'm not familiar, I guess, with specific, I don't know which specific, I don't know which groups you're speaking of at this point, but and you were there, mm-hmm. Bill, at my kickoff.
Right.
Everything that I speak, and that's why I'm so cautious as to what I say. I don't want to speak it unless I believe it. I don't want to speak it unless I actually know it and understand it. And I don't want to speak it unless I really believe that it's something that we can do and that it's within my sphere of influence and it's something that I can actually do. And so when I say that my campaign, my platform, me and what I'm doing, when I say that it is people powered, I really mean that. Anything that I present, it's because we're doing the research, we're talking to the people, we are bringing together we're coming up with the necessary resources and information needed to develop strategies and policies and the platform that it's going to take to collectively make a change in our community and to make our community safer. The only reason that I'm running is that very goal. Is I want to have hope in our community. I want to figure out and be a part of saving our young people from either death or being incarcerated. And so I really want to be a part of that change. And so any part of my platform, it's because I've done the research, I've spoken to the people, and these are the concerns that we have. And the ways that we're presenting them are the ways that I've found to be the best practices as to how to change it.
All right. We will leave it there for now. Our coverage, of course, of all of these races on the way to the May 3rd election day and early voting that begins on April 13th, you can find at dailymemphian.com. We have been talking with Janika White, a candidate in the May Democratic primary for District Attorney General. Again, this is one of 3 interviews with each of the 3 contenders in the Democratic primary on the May ballot. I'm Bill Dries, and this has been On the Record.
in-depth journalism in the Memphis community, the Daily Memphian is of Memphis, not just in Memphis, and seeks to tell the stories of this city. TheDailyMemphian.com. Truth in place.